started. Professor Nancy Whitmore, welcome to Communication Law and Policy. You probably took this class when you were at UNO.
I did. I loved it. It's a great class. What can I say?
You loved it so much you made it a career, right?
Yeah, I actually teach a class very similar. So
you teach at Butler University, and how do you address the Nebraska press case when you talk to your students?
You know, I usually take it up with Free Press Fair Trial when I do that. And it's always fun to kind of talk about it because I get to tell the story behind the story or behind the case. But yeah, we kind of look at it in terms of free press, fair trial, restrictive orders, closed trials, and that sort of a thing.
Professor Mark Scherer at the UNO History Department, you're a lawyer, first of all, so welcome. I think you're the first lawyer we've had this semester. Welcome to the class. How do you approach it as a historian?
Well, it's as Dr. Whitmore suggested, it's a great story that has a lot of appeal to students. Sadly, I suppose because of the rather macabre nature of the facts that led to the ruling. As an historian, my approach in doing legal history is to always try to bring out those human elements, the personal stories behind the stories, as Dr. Whitmore used the phrase. And it's a case that's rich in those sorts of elements. It offers the opportunity to show real human beings struggling with these sort of deep-seated theoretical conflicts that we like to explore in academics. But it's so easy, I think, when we talk about the rather, arcane elements of constitutional history and constitutional theory, to forget that, where the rubber meets the road is the way in which the places where and the way in which actual judges, actual attorneys, actual litigants grapple with these things in a real life sort of situation. So Nebraska Press Association is a classic case, and it's just made all the more useful for my purposes in that it emanates from here in Nebraska.
Mm-hmm.
What in particular about the facts made it a unique case?
Well, a couple of things. I think it's a kind of a unique case from beginning to end because the murders, the small town, the gruesomeness of them, the confession, it has all the kind of trips and traps for reporting anyway. And then 4 different gag orders, some of which, the first 2, which incorporate the Nebraska bar press guidelines, which are guidelines. They are not meant to be in law. They were vague. They hamstrung the press. I was looking back at some of the stuff that I had written before, and the preliminary hearing happened on October 22nd. They didn't get to report what was said in an open court until November 20th, after November 20th. That's a long term. I think that the fact that the Nebraska press kind of held itself to the restrictive orders as much as they could. The restrictive orders created an enormous amount of publicity, some of which was from the national press, which ignored them. So it just, everywhere you look, it's a good case.
I would agree with that. I mean, the rural and isolated nature of the community where this takes place was really central, I think, to, a lot of the later analysis of what the trial court judges Ruff and Stuart were trying to do with it. It was given the low population base of the counties involved. I think that's what made it so important, at least from the trial court's perspective, to do what they could or what they perceived to be viable sort of steps to try to limit the potential pretrial publicity. So, but you're exactly right. I can't improve on what Dr. Whitmore said. It's a combination, a confluence of really complicated things that, or at least multi-layered things that help to add to the intrigue of the case.
I always thought it was interesting as a journalist. I experienced sort of the impact of this case in the late 1970s, early 1980s, and part of that was that there was change of venue used more. I spent a month in Terre Haute, Indiana, covering a capital murder case that had been moved a couple hours north from Evansville, Indiana, for that reason. And yet in this case, they were facing a time element and issues with moving it very.
You're freezing a bit for me. Could you repeat?
Yeah, I'm sorry. I was asking, in this case, there was a time element, I believe 6 months, that they had to go forth with the trial, and difficulties in using change of venue, right?
In the Nebraska press case?
Yes.
Yes. Okay. What was told to me was that Judge Stuart they didn't want to move it. One thing in Nebraska law said you could only move it to the next county over, and they thought, well, what good will that do? And then again, I think it was Judge Ruff told me that Judge Stuart wanted to sit on the Nebraska Supreme Court and really wanted to get the conviction himself. So there was Dr. Shearer said, there's more intrigue, there's personalities, there's goals that certain folks had that maybe changed their judgment. It also, when I look back at it, it was a time that was, like you said, more untested, and they weren't using change of venue, closing the court. There was a statute against that, and Judge Ruff thought, I can't close the court. He had apparently just gotten back from some judicial training in Reno, and he learned how to make restrictive orders, and that's what he went to. So I think that we're a lot further along in the Free Press Fair Trial situation. They have a lot more tools to use. So I think it was kind of a time that was really untested waters that they were in.
We've talked at some length in the class so far that the First Amendment clearly is not absolute as it applies to free speech and press. And yet here, the Supreme Court went pretty far in suggesting that restrictions on the press are suspect. Am I fair to say?
Yeah, I would agree with that. Nebraska Press Association has become, universally recognized as the leading Supreme Court opinion on this issue of judicial gag orders, and it's made it quite clear that these sorts of efforts are presumptively unconstitutional, and if you want to get them justified in some way, you have to meet some pretty rigid standards for justifying them. And so, I think to a significant extent, MPA has gone a long way toward eliminating direct efforts by courts to gag the press. I may be getting a little bit ahead of the conversation, but obviously the battleground has now shifted to what we might refer to as indirect gags, directed against participants in the trial. But any ongoing efforts by courts to directly stifle press coverage of publicly available information related to trials is for all intents and purposes now been eliminated. And that is a direct legacy of Nebraska Press Association.
This decision cites obviously prior restraint, subsequent punishment law in Near versus Minnesota, in the Pentagon Papers case. Some of my students still struggle with this idea of prior restraint versus subsequent punishment. How do you frame that?
Well, I think there is kind of a gray line, because sometimes we talk about when law is written, just by virtue of it being written, people tend to chill themselves, and that can actually act as a prior restraint on what people want to say. So I can understand the kind of the confusion. It tends to be, the way that I describe it is going back more to government knows you have something and then basically writes an injunction on you, knows you have it, knows that you want to publish it, and in that step comes in and puts an injunction on you. But we don't see it as much as we used to, I think, is one reason students struggle. And I don't know if it would ever be workable anymore, given the media that we have now.
Yeah, I mean, I would have certainly, I'm sorry, go ahead.
No, you go ahead.
I was just going to say that, yeah, I mean, it's become sort of a truism that for me, the most complicated piece of this whole thing today is who qualifies as a journalist, because anybody with a computer and internet access can become a disseminator of information. And as Dr. Whitmore suggests, I mean, efforts at prior restraint, setting aside any sort of constitutional concerns, are, as a practical matter, just virtually impossible to enforce. So yeah, I think that's certainly part of why students might struggle a little bit with the conceptual understanding of the distinction. But beyond that, I think that's also part of the reason, in addition to the effect of Nebraska Press Association, I think the reality of social media, the reality of the world we live in today is such that prior restraints are generally or virtually extinct.
There was a case last week that relates to what you're talking about, who's a journalist out of Arkansas, where a blogger was involved in a libel suit, and a judge ruled that shield laws don't protect bloggers like they protect professional journalists. So I think that helps make your point in that regard, that there is this gray area of who is the press. And Nancy, as I've read over the years, there is some debate among legal scholars about the meaning of the press clause in general.
Yes, I think some look at freedom of the press and the clause as just the right to publish. And then I think that some look at it as maybe giving some right to news gathering, but it does, when I teach it, I think I'm more in the idea of that it gives you the right to publish, but yet that also is a part of the speech as well. I tend to focus on speech probably more than press because there's more cases. It almost seems like press has been usurped into speech, and it's just kind of one big thing. So it is difficult. It is definitely difficult.
I also think it's interesting when we look at this particular case that, unlike leaked information to the press, in this case, it was information that they obtained in an open courtroom, right, Mark? So
yes, that's correct. And that was part of the outrage, for the Press Association, was that they were effectively being banned from publishing material and information that would have been freely available to anybody who simply walked into the courtroom during the preliminary hearing, or went into the clerk's office and examined the paperwork that had already been filed in the case, et cetera. That just added to the outrageousness, I suppose, of the order as far as the MPA was concerned.
How would the case have been different if the judge had closed that courtroom?
Well, hypotheticals like that are always difficult to wrap our minds around, but I suppose there would have been a perceived greater ability of the court to enforce its order under those circumstances. I don't think that it would have ultimately affected the way that the reviewing courts ultimately looked at the overbreadth of the order, even as Judge Stuart modified Judge Ruff's original order. As Nancy recognizes, and as my work does too, that there really wasn't that much difference between Judge Ruff's order and the purportedly more limited order that Judge Stuart had put on. So the point is, I guess my answer to your question is as clearly as I can state it, is that in the final analysis, I don't think that would have made all that much difference.
Mhm.
Now, some of this information about a supposed confession and guilt was already out in the press, wasn't it?
Yes. Early on, I think they had about the murders happened on the 18th. The first order came down the 22nd. So there were a few days there that they published. And the fact that he gave a statement was widely known. And that I believe was published by the North Platte paper, but even more so, when he was at large for 11 hours before he was arrested, he had talked to his nephew and his father and confessed. Then he confessed to the police, and so that was out there. Like Dr. Shearer says, I think the town had 850 people in it. I mean, and I remember for one editor who said, rumors really weren't a problem. It was widely known. It tended to be correct. The only problem was it wasn't in the newspaper, so.
Yeah, the other wild thing about the fact pattern was that for whatever reason, the prosecution went way beyond the necessary burden of proof in the preliminary hearing itself. They could have easily just put on some quick medical testimony, maybe some very quick forensic testimony, and gotten the probable cause to bind over. They went on for hours with all this very detailed testimony that you normally wouldn't see coming out until trial. And so again, that just added to the almost bizarre sort of nature of the backstory, so to speak, to these orders. And, to add to what Dr. Whitmore's already said, her research and her interviews with Judge Ruff in particular were very valuable to me and later analysts of this, because they made it clear that Judge Ruff was most interested in not getting slapped down by Judge Stuart. And he's also, like I said, the judicial conference he'd been to was very present in his mind. This is still relatively recently after the notorious Sam Shepard murder case in Ohio that had resulted in a great deal of backlash against trial courts that had not adequately protected defendants from prejudicial pretrial publicity. So these were all the sorts of things that were jostling around in Judge Ruff's heads, and later to some extent Judge Stewart's as well, as they grapple with these issues. I think he said to Dr. Whitmore back when she interviewed him that his main concern was he didn't want to get reversed. He didn't want to be chastised by Judge Stuart for not, or any other later reviewing court, for not having adequately addressed the issue.
Do either of you think that this case is really a product of the time that it happened? And I'm thinking of the mid 1970s as a time in which it was local television news was really developing in a way that it hadn't before. And so there were those TV cameras, those TV reporters. Does that kind of heighten the intensity to the?
I believe it did. I believe it startled the folks in the area in North Platte and in the I remember reading, or there were helicopters overhead, news helicopters, I think they were just inundated. It wouldn't be inundated as it is today, but there, I think it was quite shocking. And I remember Judge Stuart saying that the person in the local TV area there had a theater degree, not a journalism degree. And he was so concerned about that they would not, basically follow the guidelines and be responsible.
Yeah, I think your point's well taken as well, Jeremy, that, context is everything. And the context here was that, in that day and age, I mean, this was my high school years, I guess, but, there were 3 channels that most people got at best. And so if you get a concentration of 2 or 3 TV channels with their helicopters, with their hordes of reporters, plus national press that began to descend on tiny little Sutherland, Nebraska, and North Platte, it's going to shake people up. And, we talk about the effects of the wide-ranging dissemination of journalistic type of behaviors now across hundreds of channels and all the blogs and websites, et cetera. I guess there's a reverse effect here when you only have 2 or 3 and they are all focusing exclusively or predominantly on this one topic. That just accentuates the impact as well, I would think. But I guess that's largely educated speculation or semi-educated speculation. But I think you're onto something there when you certainly from an historian's perspective, context is absolutely critical to understanding any storyline. And that's part of the context here.
As somebody who works currently with some rural communities on their Facebook presence and other social media, I do wonder how this kind of set of facts might play out with, a cacophony of comments on a Facebook page or tweets, live tweets. Has anybody thought about that, or are there any examples in the present that give us indicators of what might happen?
Well, go ahead, Nancy, if you want to. I was going to comment on a fairly recent Georgia. There's been you guys are probably as aware of this as I am, but there was a Georgia Supreme Court opinion in a celebrated criminal case that led to what I think is a pretty useful precedent on this issue of indirect attempts to gag the participants in trials. And the court did speak to get to your point, the court did speak to the issue of anonymous or even named internet sources that are out there with all of these tweets and all of the Facebook posts and all these sorts of things. And again, I think the bottom line for me was that the court came away with I think a very perceptive and accurate, in part sort of common sense sort of observation that as a practical matter, there's no way that these sorts of gags can have any effect when you have this sort of environment. I don't know if that speaks to exactly what you're asking, but it does seem to me to be at least one of the more notable recent. It was just a couple of years ago, 2018, I think. It does reflect a relatively recent conclusion by a high court, in this case, the Georgia Supreme Court, addressing this very point. And again, I think if and when we get a Nebraska Press Association type ruling from the United States Supreme Court that addresses the propriety of indirect gags on trial participants, which I would hope that the court will entertain at some point in the near future, I would hope that the court would make a ruling that's very similar to Nebraska Press Association in terms of explaining the severity, the dangers of these sorts of things, and the practical ineffectiveness of them in accomplishing their perceived goals. That's, as usual, a long-winded answer to a relatively straightforward question, and I'm not sure that addresses what you're saying.
But I think it raises an important point, which is if there are anonymous, say, Twitter accounts out there tweeting, and you had some kind of order, the enforcement would really fall to non-governmental entities like Twitter and their terms of service, and the same kind of thing we've seen with shutting down former President Trump's account, that a lot of the squelching of free expression now, Nancy, isn't it this type of activity that doesn't really involve government censorship, prior restraint?
Yes, I would agree. But like you said, you have to depend on Twitter, and they don't necessarily have to do it. I don't know what you would do if they decided not to do it. So I think in that way, I think the government's hands are kind of tied there. Then they can threaten regulation and, this and that, and be a good citizen, all of that. But in the end of the day, if Twitter doesn't want to take that stuff down, or any other social media, even if they did, it would just pop up somewhere else, which we're seeing because of the riots and things like that. I think that the court has to come up with, tools like it did after New York, or after Nebraska Press. It still has quite a bit of tools to try to keep evidence from getting out there, sequestering jurors, and things like that. Trials are usually, obviously, a local entity, while this is all going on nationally, but there are ways to sequester your jury. But before that, it is a problematic period.
So in the end, Professor Scherer, is it really fall back to the lawyers to exercise all of those tools that are available to them, as you mentioned, at pretrial and beyond, to limit what the press hears in open court?
Well, yeah, I mean, you're mentioning lawyers and their roles here raises another layer of this whole question, and that is the varying ethical standards that are really apply on a kind of a state by state basis to attorneys in dealing with these sorts of issues. Here in Nebraska, we do have an ethical rule that does pretty explicitly limit attorneys' ability to express certain sorts of things or to discuss certain sorts of issues in a public way within the trial setting. The essence of our ethical rule on this point is to basically adopt what's called the substantial likelihood test, which we may be getting down into the weeds here a little bit more than you wanted to, but the way that on this issue of the constitutionality of what we call indirect gag orders, that is, gag orders on participants in the trial rather than gags against the media itself directly. The courts are all over the place, basically, on the constitutionality of these things, and it varies by state, it varies by circuit court. I think, generally speaking, the courts are more willing to allow these reviewing courts are more willing to allow these sorts of indirect gags, and obviously, than they are direct gags on the media. But there is a significant minority of case law out there that strikes down even these sorts of things. And the point here, the point I'm trying to make is that the courts have very broadly and generally kind of enunciated three different types of standards for when indirect gags are constitutionally permissible. The most stringent test is the sort of the strict scrutiny sort of test. That's kind of like what Nebraska Press Association imposed for direct gags. Then there is a substantial likelihood test. In other words, it's okay to it's okay to gag trial participants if there is a substantial likelihood that the things they're going to say could in fact materially prejudice potential jurors. And then there's a final one that I think is called maybe the reasonable likelihood, which is a little lower standard. And the point of all of this is that lawyers here in Nebraska, although again, it varies from state to state, lawyers here in Nebraska are bound by that substantial likelihood test, which does in fact play into these indirect gags as it relates specifically to lawyers' responsibilities. And so again, like I said, I just consider that to be another layer of this discussion that really your students, I think, in communication law type courses need to be aware of.
Excellent. We're short on time, so I want to turn back to Professor Whitmore. Anything else that you want to add about this topic that we haven't talked about, that I haven't asked about?
Well, I don't have anything in particular, but I do think that the whole free press, fair trial area of law is, I mean, it is a complicated area of law, and the standards are, like you said, like substantial likelihood, and it definitely gets down into the weeds. But I think sort of a general thing is that restrictive orders probably out for, as far as, I think Nebraska Press will stand as far as just preventing that, but that judges have other tools that they can use, gagging participants, closing courts for a small amount of time, moving trials, and those are the tools I think that are probably most pertinent now than the prior restraint will ever be.
Mark, anything to add?
No, as I said before, I've probably monopolized too much, and I can't improve on Dr. Whitmore's analysis. I guess my concluding statement would be, to borrow from the Washington Post masthead, democracy dies in darkness, justice dies in darkness as well. And so I would just urge your students to constantly be vigilant against any tendency on the part of the courts to try to restrict access to the court system. And I'll let it go.
And I like your point more generally, to keep in mind state law, because it comes up in defamation, it comes up with shield laws, it comes up with privacy, and it doesn't allow us to completely generalize across 50 states in some of these areas.
Couldn't agree more.
Well, I want to thank you both for joining me again and talking with our students. And I'm sorry we couldn't have them here to ask whatever questions they had, but I tried to channel them in my questions. It was great to see you again and talk about this important case.
It's nice to see you.
Been enjoyable. Thanks very much.
Good
Take
luck.
care all.